This NewsTalk 1010 podcast is brought to you by PocketEmploymentLawyer.ca. Wrongfully dismissed, changes made to your job, lowballed on severance? Find out if you have a case before you call a lawyer. Go to PocketEmploymentLawyer.ca.
For Canadians who have lived through divorce, coming to the end of the process is likely a long-awaited release from personal and financial ties with a former spouse. But what many fail to realize is there are times when agreed-upon payments and settlements can be revisited. In fact, most separation agreements include provisions stating the need for former spouses to annually exchange financial disclosure documents, which can potentially act as a catalyst to revisiting support amounts if there is an increase in the payer's income. Joining us to talk about this is Laura Paris, associate lawyer at Shulman Partners LLP. Welcome back to the show, Laura. Great to have you.
Thanks for having me.
You know what? I'm going to tell you the first thing a lot of people are going to say when they hear this is, oh, that's just greedy to go back for more money. Can you address that?
Yeah, so I mean, the concept behind it essentially is if you see a post-separation increase in your spouse's income, if the increase is related to a career that was held by the spouse during the relationship, the spousal support guidelines essentially want the spouse who's the recipient of the support to continue to benefit from that income. And the rationale behind it is that the payor would not be able to achieve that position, would not have been able to achieve that increase in their income had it not been for the sacrifices made by the recipient during the relationship.
I'm sure there are a lot of payors who would disagree with that.
Oh, there's many, and listen, it's a very difficult conversation to have, and one that I have more often than less. And again, I mean, I can understand both sides of the coin. On the one side, you have the payor sitting there saying, I have to, I already work hard. I already work hard to make this income, and now you're telling me that I have to work even harder to continue to support someone that I'm not even with anymore. And I get that. I get that side of it, but you also have to look at the flip side and say that there are, there is this other person who made a lot of sacrifices for the relationship and may not have the ability now to earn what the other spouse is earning. So they need to be compensated for those sacrifices. And again, I understand the frustration, but there is some logic behind it.
Sure, of course. So is it ever a situation where the payor gets a new job? Does it have to be the job they were in when the marriage was still a thing, or can it be a different job that pays more money and the payee finds out about it and goes back to court and says, well, they're making that much more money, so I feel like the support should be increased?
So it really depends. I mean, if, for example, let's say someone was a real estate agent their entire marriage, and then they decide, after separation that they're going to go to law school and become a lawyer, and now their income has, increased to double what it was that they were making as a real estate agent. There would be an argument there to say that this income that's now being earned in the legal career has nothing to do with the marriage at all, because the spouse has now retrained and done all of these things outside of the marriage in order to get their income to now where it is. In a circumstance like that, you'd have a strong argument to say, no, you're not entitled to my post-separation increases in income. Now, if you're looking at someone, for example, who held, let's say, an associate level position when they were married, and then post-separation they become a partner at a law firm, something like that, you would say certainly there are connections to that, and that also can apply to a change of career. If you can find a correlation between the career that was held during the marriage and the new position that was taken post separation, then certainly there could be an argument to say that there is an entitlement to the post separation increases.
Okay, that makes perfect sense. Let's talk about some of the circumstances that impact spousal payments. One of them, I guess one of the biggest ones, is how long were they married or living together?
Absolutely. So when you're looking at the spousal support guidelines, we look at a few things. We look, one, at whether or not there were children, two, what the incomes of the parties are, and three, the duration of the relationship. So you see in longer relationships, long-term relationships, which fall, I guess anything 15 years and up, you see that support obligations are a lot longer in those situations. That's when you start seeing that support's payable, even for indefinite periods. When you have a short-term marriage but you have young children, you also see a longer duration. So there's a lot of different factors that can play into it. Now, the general way to look at it is the longer you're married, likely the longer your support obligation is going to be if there is an entitlement. And that's another important piece. There needs to be an entitlement first before we even get into the discussion as to whether there is going to be any support owing, the amount and the duration of it.
Can you explain what that means, what you mean by entitlement in this context?
Yeah. So when we're looking at spousal support, we're essentially there's two ways to look at it. There's need-based claims, and there's ones that are meant to compensate people for sacrifices in the relationship. So when you're looking at something like need or lifestyle, you're essentially looking at what the lifestyle was that was shared during the relationship. So for example, if there's a big disparity in income, usually you will see entitlement to support in those circumstances. Just because there's a lifestyle that is expected to be maintained. If support if an entitlement is based only on kind of that lifestyle claim, you see it payable for shorter duration. So essentially, here, I'll give you support, let's say for the next 5 years, to get yourself kind of back on your feet, but the expectation is in that 5 years, you are then going to take steps to become self-sufficient, and then I'm going to be off the hook. Then there's the circumstances where support is payable as a result of compensatory claims, meaning that you sacrifice something as a result of the marriage, and now, because of the marriage, you don't have the ability to be self-sufficient or to become self-sufficient, as quickly as you could have, had you continued your career throughout the marriage. So, these things come down to, people staying home and not continuing with their career, or people, taking time off work and then having to go back to become retrained. So with compensatory claims, that's when you see support being payable for longer durations.
Is there any kind of situation, aside from the one that you explained very well about switching careers, retraining, is there any other kind of situation where the payor would come into money and the payee would not be entitled to any of that? Like, I'm thinking of maybe an inheritance.
Yeah, inheritances are that would not fall into the support scheme. You could make a pretty strong argument that it shouldn't. For the most part, when dealing with family law issues, period, even in terms of division of assets, inheritances are usually exclusions. And the rationale behind it is that an inheritance is essentially a gift. It's not meant to be shared. As a result of a relationship. It's not something that was built together through the relationship, and therefore it shouldn't fall into the relationship at all, whether by way of support or by way of any sort of property entitlement or asset entitlement.
Always great to have you on, Laura. Thanks so much for this.
Thank you.
Laura Paris, associate lawyer at Shulman Partners LLP. You are listening to The Nightside.
This NewsTalk 1010 podcast was brought to you by PocketEmploymentLawyer.ca. Wrongfully dismissed, changes made to your job, lowballed on severance? Find out if you have a case before you call a lawyer. Go to